But without further ado, I would like then to give the floor to my colleague Karen. Karen will present a paper entitled Post-Brexit UK Data Protection, Staying the Course or Charting a New One. Karen has written extensively on the topic of Brexit and data protection. She has been one of the voices to map what was going on in the UK at the moment. So we look forward to hearing from you. Thanks. Thank you so much, Karen, for joining us in person today.
Thank you. I will just share my screen. Good afternoon, everyone. Sincere apologies for all the technical delays. Unfortunately, my university gave me a new computer, and it seems that I hadn't thought through that you have to update absolutely everything to make it work. So apologies for the slow start to this presentation. But as Eduardo has just said, I'm here today to discuss post-Brexit UK data protection, staying the course or charting a new one. And as Eduardo has already mentioned, there's the suggestion that the UK is planning on embarking on a new course, doing its own thing. And I will talk to you about this in two different ways. One, is that possible? Or two, could we find a middle way which might keep everyone happy? And whilst allowing the UK politicians to claim that we are diverging, that we are creating or charting a new course, when in fact we could actually be simultaneously maintaining alignment. So that's what I'm going to discuss. So, just to recap, when the UK was preparing to leave the European Union and become a third country for data protection purposes, it opted to maintain alignment with the GDPR, and it applied for an adequacy decision from the European Commission. And it did that to facilitate continued seamless EU-UK personal data transfers. Now, a few months later, having gained an adequacy decision, it is consulting on proposed changes to UK data protection law, and it's doing that through the DCMS Data A New Direction consultation. This consultation framed its proposals as being focused on seeking to reimagine and modernize the law with the goal of fostering and encouraging innovation whilst protecting personal data. Somewhat surprisingly, from a data protection lawyer's perspective, but perhaps understandable from a political perspective, given the politics of Brexit, the consultation does not ask respondents to consider all proposed reforms through the lens of maintaining essentially equivalent level of protection to that in the EU, even though divergence might jeopardize the existing adequacy decision. So the purpose of this talk then is to illustrate by reference to a multi-dimensional model of adequacy, how the UK's adequacy application was assessed. And then secondly, to explain why the UK may not be able to diverge from the GDPR to the extent that the DCMS consultation proposals would suggest, if it is to actually retain and thereafter obtain periodic renewal of the adequacy decision. And then I will gently, hopefully, not known for gentleness or subtlety, but I will try and suggest that we may be able to suggest that the UK is achieving its political goals whilst also maintaining its legal obligations by trying to develop UK data protection law in a way that allows it to maintain alignment with the GDPR whilst also claiming political independence. So that's the path in which I'm going to try and take you in this talk. So when we talk about adequacy decisions, there's a lot of commentary out there that the adequacy assessment process is very opaque because we're not entirely sure how adequacy assessments are conducted, because when countries apply for an adequacy decision, the talks take part between the applicant country and the Commission, and very little information is revealed to the public. And in fact, if a country's application is not successful, we do not find out about that because it's considered to be politically sensitive. So what I'm trying to do here is actually say that in my view, we can actually formulate a multidimensional assessment of adequacy. And I'm going to take this opportunity to demonstrate that a close reading of Article 45 of the GDPR reveals that there are 4 dimensions of an adequacy assessment. So this is an opportunity. This is only our second adequacy assessment issued under the GDPR. Japan was first, and now the UK is second. And I say that if we look at Article 45 and read it closely, we can identify 4 different dimensions of an adequacy assessment. So the first one is a jurisdictional dimension. And that is concerned with, firstly, the power that is vested in the Commission to make an adequacy decision. And secondly, the attendant oversight and enforcement mechanisms that are exercised by other EU institutions. The definitional dimension is concerned with the de jure substantive protections that are applicable to personal data. The third dimension is the operational dimension, and by that, I mean a concern with the de facto effective rights and oversight and redress mechanisms that are available. And the fourth one is the temporal dimension. And by that, I mean a concern with when an adequacy decision can be sought, how long it can take to complete, and how often it is reviewed. So I'm going to talk you through each of these 4 dimensions in greater detail, both in terms of the initial adequacy assessment process that the UK underwent, and then also reflecting on what the DCMS consultation proposals mean in view of a future review of the existing adequacy decision. Because as we all know, if the UK diverts to a significant level, that could trigger a review and perhaps revocation of the adequacy decision or refusal to renew it. So let's start with the jurisdictional, whoops, I've skipped one. Let's start with the jurisdictional dimension. So the first thing to note here is that the Commission has unilateral power to adopt adequacy decisions. So even though the day before the transition period ended, the UK was considered to be fully GDPR compliant, it could not unilaterally, the UK government could not unilaterally declare itself to provide an adequate or essentially equivalent level of protection. The only body that could do that was the European Commission. So the UK could not make any declarations of essential equivalence, only the European Commission could do that. As for why that is the case, it's because an adequacy assessment provides a legal mechanism for building and guaranteeing trust regarding data processing. So the EU, as we all know, is a legal order, and it builds and maintains trust within that legal order using legal mechanisms. So that's the purpose of an adequacy assessment, a mechanism for building and guaranteeing trust. And that's why it's only the European Commission that can make these decisions. But I should say that other EU institutions exercise a supervisory role, both during the initial assessment process and thereafter on a continuous basis in respect of adopted decisions. And anyone working in this field will know that there have been complaints by the Parliament and the Council about the US Privacy Shield, and that has led to the revocation. So we see both the European Commission being involved and the other EU bodies exercising a supervisory role. So what I would like to flag up at this stage is we can now recognize that the UK is a third country for data protection purposes. It has restored its legislative sovereignty. It is free to make whatever data protection laws it wants, but it needs to keep in mind that if it wants to retain an EU-UK adequacy decision, the body that will decide whether or not we're adequate is the European Commission. So it needs to be cognizant of what the European Union expects in terms of if we want to have our cake and eat it, then we've got to remember just who has the power to make these adequacy decisions or revoke them or renew them. So the second and interrelated dimension is the temporal dimension. And that's the temporal dimension relates to the scheduling and prioritization of adequacy assessments. And that is determined by the European Commission. So for example, when the UK first sought an adequacy decision, it was 13th in the queue. So there were 12 countries ahead of it. But the European Commission decided that because of the trade relations that and the trade negotiations that were ongoing between the EU and the UK, that it would prioritise the UK's application, and indeed it did. I should say that the UK did receive an adequacy decision. It was adopted, but it's important to remember that an adequacy decision is a living document. And that has the consequence that there will be a periodic review of the adequacy decision every 4 years, and that the review could take place more quickly if circumstances warranted. For example, if the UK does something radical in terms of the DCMS proposals that it is currently discussing. So we are going to be under a process of review in relation to the adequacy decision. What I would like to turn to now is the definitional dimension. So this is concerned with the de jure substantive protection applicable to personal data. And during the initial adequacy assessment process, this element was largely unproblematic. And that was because the UK had, first of all, implemented and then retained the GDPR in UK law. So it was essentially a copy of the GDPR. So far, so good. You would expect to pass this step with flying colours. But I should draw your attention to the fact that the adequacy decision did not cover transfers of personal data to the UK for immigration control purposes. And that was because the European institutions had complained that the immigration exemption in the Data Protection Act 2018 was too broad in scope. If you read the documentation closer, if you're following the negotiation process, you will see that the European Commission was inclined to give the UK a pass on this deficient provision in the data protection legislation. But the Parliament and the Council got involved and they said, no, we're not going to rubber stamp this deficiency. And so eventually it was agreed that this would be excluded from the adequacy assessment decision, and that it would be revisited after the UK had amended its law. So this was an example of the European Commission using its powers to check that an applicant third country was compliant, providing an essentially equivalent level of protection, and then put in place impediments or restrictions when it was found not to be providing an adequate level of protection. So that gives you an indication of where we might run into difficulties if we introduce significant reforms through the DCMS consultation. And I will just talk you through two examples in relation to the DCMS consultation. So the first thing I want to say to you is that we need to be aware that the first question we need to ask ourselves is it permissible for the UK to develop its own data protection strategy? And the answer to that question is yes. Firstly, because it's a third country, it has legislative sovereignty, therefore it can develop its own data protection policy. Second question is, can we do that in a way that maintains alignment with the GDPR? And my answer to that is also yes. And I would say that the answer to that is yes, because the GDPR, or the UK GDPR, contains a lot of white space. So there are provisions that countries are free to interpret and develop in a way that suits their needs. So if I talk you through two examples, I want you to realize that whilst we do have white space, we have to be careful how we go about interpreting those provisions. So an easy example of white space or derogation or freedom that a member state or a third country has is in relation to the age of consent for the processing of personal data. So all countries were free to set the age of consent anywhere between 13 and 16 years of age. If you do that, then you are in compliance with the GDPR. But if we take a look at the DCMS proposals, we see that the UK can and should use the white spaces that it has in the framework to develop its own data protection law to suit the particular needs of the UK. But I would suggest that we need to do that in a way that maintains compliance with the GDPR. And just to give examples of where we could run into difficulties, the first example is in relation to research. So the DCMS proposal is saying that we need to clarify that consent to research may be provided in very broad terms. It is suggesting that we make explicit that further processing for research purposes is always lawful and always compatible with the original purpose for collection. And it is saying that we should provide a disproportionate exemption for controllers to reuse personal data for research purposes, and that they will not have to notify individuals of that research purpose because it would be disproportionate effort on their part. What I would say about this is that it's a very broad approach and it's likely to prove problematic. It's not balancing the rights and interests of the different parties sufficiently proportionately to comply with the EU legislation. If I give you a second example relating to legitimate interests, the DCMS consultation proposes that the balancing test that exists between the controller and the data subject be changed so that the controller's legitimate interests always prevail in certain limited circumstances. If we follow that approach, then the data subject's rights to object processing will be negated. If we do that, that's likely to represent a significant divergence from the GDPR requirements. So what I would say is, if these two proposals are adopted in their current form, then they're likely to be found overly broad and represent a significant divergence from the requirements of the GDPR. That could trigger calls for an adequacy decision or UK adequacy decision to be reviewed and perhaps even revoked. So the point I would like to make here is that there is white space in the GDPR and the UK GDPR. We should use that white space, but use it carefully to develop laws that are fit for purpose in the UK, but are also at the same time compliant with the requirements of the GDPR if we want to retain and renew an adequacy decision. So if we move on to the operational dimension, as I mentioned before, this is concerned with the independence of the supervisory authority and the effective and enforceable rights and redress mechanisms available to individual data subjects. I would like to focus your attention on the independence of the ICO, because I would contend that the independence of the ICO will be undermined if some of the proposals in the DCMS consultation are introduced as they currently stand. So for example, there is a proposal that the Secretary of State for DCMS will prepare a statement of strategic priorities to inform how the ICO sets its own regulatory policies. Does that sound independent to you? If you're told what your regulatory priorities are, that seems to undermine your regulatory independence. There's a second proposal which is interesting, and that's a new concept of preventative supervision. So it says that the ICO shall have a preventative supervision role, but it doesn't explain clearly what is meant by preventative supervision. And so I would argue that if this represents a fundamental alteration of the ICO's role, for example, if it transforms its regulatory risk, if it transfers the regulatory risk from the data controller or the data processor to the ICO itself, then you're fundamentally changing the role of the regulator. So, preventative supervision is something we expect data controllers and data processors to assess the risk of their data processing activities. We do not expect the regulator to do that on behalf of the data processors and data controllers. And if we're changing the role of the ICO in that way, then I would say that that is undermining the role of the ICO. There's another proposal in the DCMS consultation, which is that the ICO is to help and encourage responsible uses of personal data. But as we all know, you can have many different arguments as to what is responsible and what is a responsible use. And the DCMS consultation doesn't give clarity as to what is meant by that term. And the ICO could find itself in a very odd position of having conflicting arguments about what constitutes a responsible use. And if so, that's undermining the role of the ICO as well. So I would say that we will hopefully in the next few months find out exactly what the government has in mind for these terms, and also take the opportunity to consider whether the DCMS proposals can be refined, narrowed in scope, and perhaps looked at through the lens of GDPR compliance, even if that is not made explicit because it might be politically controversial. So where I would like to end is by reminding everyone that we do have white space in the GDPR and the UK GDPR. We should take advantage of that white space. We should use it to develop data protection provisions that suit the needs of the UK. But we should also remember that the UK GDPR operates in a global environment of data protection laws. And that matters because the UK economy is a service-based economy. We are reliant on the transfer of data to and from the UK from all around the world. And I would like to draw your attention to the Brussels effect and say that size matters. So the first thing when I say about Brussels effect is that it's known, this concept was identified by Anu Bradford, and she has said that there is a regulatory rush to the top. So whatever is the most stringent rule is what you will see businesses eventually seeking to promote compliance with. And the reason why they do that is if you are, for example, Facebook operating in California, or if you're operating in Singapore and you're trying to process personal data on a global basis, you figure out what's the most stringent compliance rules and you implement that across your business, because if you're compliant with the most stringent rules, then you'll not run into legal difficulties elsewhere. So there isn't really a market for exceptionalism here. That's not in the interest of businesses. There is no rush to the bottom because of the way that the GDPR is designed. It's designed to promote a rush to the top, a rush to high standards. And when I say size matters, usually I would argue that, you know, being small is not a problem, but on this occasion, I'm going to say that actually the size of your economy does matter. There's no point in the UK carving out a significantly different legal strategy if that has negative economic consequences. So if we diverge to a significant extent to the point that we make the transfer of personal data to and from the UK more problematic, then we could actually see businesses relocating their place of establishment outside of the UK. So I would conclude by saying we have the white space. We should use the white space because if we, and we should use the white space in a way that allows for creative development, but have a mind or an eye on the need to be GDPR compliant, because if we don't, we're going to find ourselves drawn back into the review process by the jurisdictional and temporal dimensions of the adequacy assessment process. So I would end by saying, for political reasons, we probably will say that we are forging our own path, and quietly, we will ensure that that path that we chart ensures alignment with the GDPR. Thank you for your time and attention.
Thank you so much, Karen, for this extremely interesting and very well structured, I have to say, presentation. I really appreciated your way of approaching the adequacy decisions, starting from 4 different dimensions. And I found your your findings related to the way in which actually the UK may effectively operationalize the future development of the adequacy decision extremely sound and pragmatic. And I see also that we have in our Zoom audience Professor Edgar Morgenroth will be actually the chair of the next panel, who is an expert from more the economics and business perspective, is the one of the heads of school here at the DCU School of Business, and is also has been one of the voices in relation to Brexit in Ireland. And I would like him maybe to ask a question about the economic effects of this development. But I will leave, of course, this question for later. But I'm really happy to see that this question of the interlink between future legal development and economic developments have been already highlighted in this first paper. So thank you very much, Karen, for this.